Good morning, everyone, and thank you for joining us bright and early for this flash update webinar on the Supreme Court's highly anticipated judgment in URS and BDW. Given the significance of the case, the industry as a whole, we thought it'd be useful to discuss the main aspects of the Supreme Court's decision. And in this discussion, I'm fortunate to be joined by 4 colleagues, each of whom has extensive experience and expertise in building safety cases. We have David Sawtell, Camilla Ter Haar, Samantha Jones, and Alex Burrell. Now, although I'm sure everyone is very familiar with the facts of the case, I will begin with a brief recap. So in 2019, following investigations prompted by the Grenfell Tower tragedy, BDW found structural design defects in 2 of its developments. And in both cases, URS was responsible for the structural design. Now, by this time, BDW no longer had any proprietary interest in either of the developments. The flats had been sold on long leases to residential purchasers, and the freeholds had been transferred to property management companies. Now, despite not having any proprietary interests, BDW carried out extensive remedial works to the developments and then sought to recover its losses from URS. BDW issued its claim before the Building Safety Act was in force, and so initially only claimed in negligence. Now, in the course of those negligence proceedings, preliminary issues were ordered and were determined by Mr. Justice Fraser in October 2021. And he held, first, that the losses claimed by BDW were in principle recoverable as being within the scope of URS's duty of care in tort. And second, BDW's cause of action in tort had accrued no later than the date of practical completion and not when the defects were discovered. It followed that BDW had suffered a recoverable loss because it held a proprietary interest when the cause of action had accrued. Now, when the Building Safety Act came into force, BDW successfully applied to amend its claim to include claims both under the Defective Premises Act and the Contribution Act. URS appealed to the Court of Appeal both against Mr. Justice Fraser's decision on the preliminary issues and the decision to allow BDW's amendments. The Court of Appeal dismissed both appeals, and URS then sought permission to appeal to the Supreme Court. The Supreme Court gave permission and said that the appeal should unusually be heard by a panel of 7 judges. And the reason for having a 7-judge panel was that the Supreme Court might be invited to depart from the decision of the House of Lords in Burrell. And in fact, the Supreme Court did not find it necessary to decide whether to overrule Burrell when it came to give its decision in URS and BDW. The Supreme Court gave permission to URS to appeal on 4 grounds. And just to be clear, these did not correspond in terms of substance or numbering with the grounds of appeal to the Court of Appeal. So ground 1 before the Supreme Court was in relation to BDW's claim in negligence and putting to one side the possible impact of Section 135 of the BSA had BDW suffered any actionable loss. And this gave rise to issues of scope of duty, remoteness, and voluntariness. Ground 2 was, does Section 135 of the BSA apply to the proceedings? And if so, what is its effect? Ground 3 was, did URS owe a duty to BDW under Section 11A of the DPA? And if so, were BDW's alleged losses of a type which were recoverable for breach of that duty? And ground 4 was BDW entitled to bring a claim against URS pursuant to Section 1 of the Contribution Act, notwithstanding that there had been no judgment or settlement between BDW and any third party. And in fact, no third party had ever asserted any claim against BDW. So I'm going to ask my fellow panelists to give us their views on these grounds in a moment. But before we get started, if anyone has any questions, please put them in the chat. And if we have time at the end, we will see if we can answer at least some of them. So quite logically, we're going to start with ground 1, which Samantha is going to deal with. So Samantha, can you summarize for us the arguments advanced by URS on ground 1?
Yeah, sure. Thanks, Adam. Morning, everybody. So yes, in terms of ground 1, what we're looking at here is essentially whether the voluntarily incurred losses incurred by BDW were irrecoverable as a matter of law because they were either outside the scope of duty or too remote. There was an alternative argument pleaded, but it wasn't found necessary to be dealt with by the Supreme Court, so I won't address it. The arguments that URS put forward were based on a number of assumptions of facts that were not in dispute between the parties. So what was not in dispute between the parties was firstly that URS owed a duty of care to BDW not to cause them pure economic loss, because they fell within one of the Headley-Byrne exceptions, that there was an assumption of responsibility by URS, as they had undertaken through the contract of professional services to take reasonable care in providing structural designs to BDW such that the buildings constructed on the basis of those designs would not be defective. Secondly, what was not in dispute was that URS had breached that duty by providing negligent structural designs which had caused the defects in the buildings that BDW then had to repair. And thirdly, URS accepted that had BDW remedied the defects before they sold the buildings, therefore, while they still had a proprietary interest in the properties, that the cost of the repairs would have been recoverable. So what did they argue? URS argued that once BDW had no proprietary interest in the buildings and no enforceable legal obligation to carry out the repairs, the loss suffered by BDW in incurring those costs and expenses was outside the scope of duty of care, because the losses were not of a type and did not represent the fruition of a risk that it was URS's duty to guard against. And they argued that they were too remote because they were not within URS's contemplation of a serious possibility at the time the contract was made, and for which URS assumed responsibility. What they argued was that there was a voluntariness principle that explained why the loss was outside of scope and or too remote.
Thank you. So what is this voluntariness principle? And did the Supreme Court give much weight to that argument?
It's an interesting one. I hadn't really come across it much before. I mean, the colloquial way to summarise the majority of the decisions relied upon by URS about the voluntariness principle is that, as I see it, it's the principle of doing the right thing. It's where a party pays out monies voluntarily for damages that they are under no legal obligation to rectify, but often doing so for sound policy and or commercial and or reputational reasons. So just to take two cases as an example, there was the case of the Esso Bernica case. It's where Esso's oil tanker was damaged in an accident caused by a defect in tugs that were towing her into an oil terminal in Scotland. Esso paid out money to the Shetland Islands councils for persons, primarily the crofters, who had been affected by the oil spillage. So that was a voluntary payment that they decided to make. And then in another case, the Anglican Water case, which was relied upon, a subcontractor of Anglican Water negligently drilled through an existing water main, a gas main, and electricity cable, which resulted in 20,000 people in Corby being affected by a loss of gas supplies. What Anglican Water decided to do was to make payments to the households whose gas supplies had been affected without there being any physical damage to their gas appliances, and to the local authorities who provided emergency services. As you can probably already tell from the facts of those payments, those individuals would not have had any enforceable legal right against Anglican Water or Esso to demand those payments, but they were made essentially, I would say, to do the right thing and for good sound policy reasons. So in the four cases relied upon by URS to demonstrate the use of this principle, none of the claimants could recover against the defendants for the voluntary payments that they had made. They did manage to recover, direct payments for the losses that they suffered as a result of the negligence, but not those voluntary payments. And what the Supreme Court held in this case was that the reason for that was actually not because there was a bright line denying recovery because the payments were voluntary. It was because the voluntary payments either constituted pure economic loss rather than the loss directly consequent on damage to the claimant's property, and therefore fell outside normal principles for recovery. And as such, there was no duty of care. Or they found the loss was too remote based on the very specific facts of the case. So really what the court was saying here is that the principle of voluntariness should be actually considered as part of the causation and mitigation arguments that a party advances, rather than being one about scope of duty or remoteness. They weren't saying that you could never recover for these for these expenses and costs you paid out. And that's the point that URS were trying to argue, was that there's just no way you can recover these payments. And it will be material for these parties and any other parties to consider at trial on the specific facts of the case, whether the voluntary payments have broken the chain of causation or whether the claimant has failed in its duty to mitigate its loss. And there you're looking at the ordinary principles of reasonableness of the claimant's conduct, namely whether the claimant could have avoided its loss by taking reasonable action, or whether expenses or other additional losses incurred increasing its loss were reasonably incurred. And that's where the focus of actually the arguments about those payments should be.
Thank you. And so, having decided that there's no bright line rule and has to be decided by reference to the facts of a particular case, what did the Supreme Court decide in this case on the facts of this case?
So, as probably everybody knows, the appeal on this ground failed. Actually, they didn't say it failed for reasons of voluntariness. What they said was that there were 3 features of the assumed facts that indicated that BDW was not, in a true sense, acting voluntarily in paying for the repairs. So the 3 reasons that they found in favour of BDW on this ground was that, first of all, they found if BDW had done nothing, there was a risk that the defects would cause personal injury or death to the homeowners, for which BDW might then be legally liable either under the DPA or in contract for breach of collateral warranties. They said that such claims would not be time barred because, as we know, the cause of action would run from the date of discovery or discoverability of the injury, or the Section 33 discretion in the Limitation Act would apply so as to disapply the primary limitation period. Secondly, they found that BDW had a legal liability to the homeowner under the DPA or in contract to incur the cost of repairs. Though limitation would have barred that remedy, they said it didn't extinguish the right. It's important to remember that these findings were made without consideration of the fact that the BSA had actually retrospectively extended the limitation periods for claims under the DPA. They still found that these were good reasons why there were potential legal liability to be faced by BDW if a claim was brought. And then the third reason, which we actually saw in some of the voluntariness principle cases, was that they found that there was potential reputational damage to BDW if BDW did nothing once it knew of the danger to homeowners, such that it was in BDW's commercial interest to effect the repairs. So essentially what they were saying is BDW had no realistic alternative, and they were not acting or exercising a sufficiently free and full choice to be considered to be acting voluntarily.
Oh, thank you. So what do you think the practical implications of this decision of the Supreme Court will be?
I think so far, until we have potentially a judgment from the trial in this case, is that it's good news for developers who, as we all know and have come across, are taking the step of doing the right thing to remediate building safety defects in buildings that they no longer have a proprietary interest in. It leaves the door open that they can seek recovery for that pure economic loss where they can establish the Headley-Burn exception. And what I see it as is it really, this decision accords with the underlying policy reasons for bringing about the Building Safety Act post-Grenfell, namely that defects as grave as those that can cause injury or death must be remediated, and that parties who were negligent and are responsible for the defects should be held to account. I mean, as the court explained in its sort of underlying policy rationale for this decision, the policy of the law incentivizes a claimant like BDW to remove any danger to a homeowner. And to be honest, to have found otherwise would have been a huge blow to the residents living in unsafe homes.
Thank you, Samantha. Right, so that's ground one. I'm now going to turn to Alex. Alex, you're going to be dealing with ground two, which is a brief recap, is whether Section 135 of the BSA has any application in the circumstances of this case. So I suppose the first question for you, Alex, is what was the issue being decided in terms of limitation periods?
Thanks, Adam, and good morning, everyone. So the background circumstances to this ground are that BDW initially issued proceedings before the coming into force of the Building Safety Act, and given the timing of that, it claimed only in negligence. in June 22, we had the Building Safety Act and Section 135. So BDW immediately applied to amend their claim. The amendment sought, importantly, to delete previously pleaded admissions that at the time the defects were discovered and repairs undertaken, any liability that BDW had to third parties was time barred, and to introduce instead the allegation that by reason of Section 135, BDW's liability to third parties was not time barred. They also sought to introduce claims under the DPA and for contribution. So what was URS's ground of appeal and their basic argument in a nutshell? Ground 2 concerned, does Section 135 apply in the present circumstances of this case? And the argument was summarised, or the issue was summarised by the Supreme Court as what is in dispute is whether Section 135 also applies where, as in this case, an action is brought claiming damages for repair costs in the tort of negligence, or there is a claim for contribution, and it's contended that the repair costs were voluntarily incurred, or there was no liability for the same damage because the DPA claim, as against BDW, was time barred, or by homeowners. In other words, does the retrospectivity of Section 135 apply to claims which are dependent on the time limit under the Defective Premises Act, or applicable to the Defective Premises Act, but not actually claims brought under the Defective Premises Act? So the wording briefly on Section 1351, it introduces a new provision into the Limitation Act, Section 4B. Subsection 4 of that provides, I'll read it out because it's important in the Supreme Court's reasoning, where by virtue of Section 1 of the Defective Premises Act, a person becomes entitled before the commencement date to bring an action against any other person. This section applies in relation to the action, as if by reference to subsection 1 to 15 years, where reference to 30 years. Also relevant to Section 1353, which provides that the aforementioned reference in relation to actions brought by virtue of Section 1 of the Defective Premises Act is treated as always having been enforced. So that's the retrospectivity provision.
And what did the Supreme Court decide, and what were the key factors the Supreme Court relied upon in making its decision on ground 2?
The Supreme Court rejected URS's appeal, as we know, finding that actions dependent on Section 135 could be pursued, including negligence, even if they were not actions under Section 1 of the Defective Premises Act themselves. So it's splitting the key reasoning into textual and contextual, as with any interpretation of statutory or instrumental contracts. Paragraph 99, they reference the wording of the statute as I've just read out, and they give particular emphasis to the wording by virtue of, and then also the references to an action or the action, clarifying that that could be any action, not necessarily an action under Section 1 of the Defective Premises Act, and the reference to by virtue of rather than, for example, under Section 1 is clear that as a matter of language, they found that Section 135(3) is not restricted to actions under Section 1. There's also reference to the title of 4B itself being a relatively wide heading for such claims. More interesting, perhaps, though, is the contextual interpretation analysis. So at paragraph 102, they say that a further relevant matter of context is the importance of retrospectivity in Part 5 of the BSA. And it was found that this is reflected not only in Section 135, but also in all the main changes to the law in Part 5. As I'll come on to, is discussed in the judgment that the purpose of Part 5 of the BSA, including at paragraph 106 of the judgment, referencing the explanatory notes, is ensuring that those directly responsible for building safety defects are held to account was central to the Building Safety Act and various of its provisions, including 135. I'll come into that in a bit more later. So they said if 1353 was restricted just to Section 1 of the Defective Premises Act, it would undermine the purpose of the BSA, as it would apply to claims by homeowners against developers, but would not allow onward claims by those developers. A wider interpretation was needed as a matter of justice between developers and those responsible, but also to allow developers to fund their own obligations, or to meet their own obligations under the Defective Premises Act. There was some discussion within the judgment about the lack of coherence of URS's position, as it would create contradictory parallel universes as between claims by homeowners and claims by developers, which didn't logically work. I won't go into the details of that, but there's some interesting analysis on that. Finally, it was suggested by URS that BDW's argument would impermissibly falsify history because it would require a court to conclude that Section 1353 deems, contrary to reality, that at the time BDW procured the remedial works, the retrospectively extended limitation periods applied and homeowners had enforceable claims against BDW under the DPA at that time. So there's some interesting discussion by the Supreme Court on this. Firstly, they note at paragraph 120 that any statutory provision which applies retrospectively does rewrite history in a sense, at least in relation to the legal state of affairs being different to what it was at the time. But importantly, in relation to the argument being put forward by URS, they found that it didn't alter the facts. So if there is an issue at trial as to the reasonableness of BDW's actions in carrying out the remedial works as a matter of causation or mitigation, they'd be determined by reference to the facts at the time of those actions. So this is going back to the point that Samantha raised a little bit earlier, which is that will be determined by what BDW would have reasonably understood to be the position, which is that at the time they undertook those remedial works, they didn't, or they would have understood that they didn't have, or they would have had a limitation defence available to them. And Section 135 doesn't change that. So it leads an interesting implication, which is that for repairs undertaken before the Building Safety Act came into effect, it's hypothetically possible that a court could find that the works were not reasonable as they were not reasonable mitigation, or they break the chain of causation because of the subjective understanding of the lack of liability or the availability of a limitation defence at the time. That being said, though, a court may still be tempted to find in any event that after Grenfell and the general public interest in addressing fire safety defects, that's enough for any purposes of causation or mitigation. Yeah.
Right. And so what are the implications of this part of the Supreme Court's decision, both legally and practically?
So the legal consequence in a nutshell is developers can still bring claims of negligence or other causes of action in reliance upon potential liability that they would now have due to claims against them from homeowners because of this extended limitation period. The practical consequence of this is that contribution claims and negligence claims continue to be a lifeline for developers when faced with potential DPA claims from homeowners. This would potentially or will potentially lead to continued litigation or more complex litigation as more parties are able to be brought into it, and contractors and other professionals need to be aware that they are at risk of such ancillary claims. But there's also an interesting wider discussion by the Supreme Court, or the wider discussion by the Supreme Court may be of interest in terms of the intention of Part 5 and some of the comments that they make about it. So the Supreme Court, in essence, adopts at least some of the submissions made by the Secretary of State as to the policy and purpose behind the BSA. Many of these are referenced in the judgment itself, such as paragraph 87. It references that retrospectivity is central to achieving the aims and objectives of the BSA. As I've already read out, the tribunal comments itself at paragraph 102. It's a further relevant matter of context, the importance of retrospectivity to Part 5 of the BSA. And that's reflected not just in 135, but the other provisions. And then reading out at paragraph 104, a central purpose and policy of the BSA in general was to hold those responsible for building safety defects accountable. So the Supreme Court opted to take a wider approach rather than the possible narrow approach in relation to or reliance upon the purpose of the BSA in this context. And now that may have implications for other claims in relation to Part 5 of the BSA, for example, remediation contribution orders or BLOs. With reference to the retrospective effect point being central to the objectives of the Building Safety Act, this may be relevant to ECHR arguments about retrospectivity. There may be also relevance to decisions about whether a wider or a narrower interpretation of, for example, relevant defect or other parts of those tests in the RCA or BLOs should be wider or more narrow. We can see practitioners relying upon some of the paragraphs of the judgment in relation to that.
Thank you, Alex. That's very interesting. Right, so we're now going to turn to Camilla. Camilla, you're going to deal with ground 3, which was whether URS owed BDW a duty under Section 11A of the Defective Premises Act. And I suppose the obvious question is, why was this an issue at all? Surely Section 11 of the DPA is clear, and URS did owe BDW a duty.
Well, thank you, Adam. Good morning, everybody. We're just going to looking at the Section 1 itself to start off with. Those listening will be very aware that the duty under Section 11A of the Defective Premises Act is owed to those who order the provision of a dwelling. And the duty under Section 11B is owed to every person who acquires an interest in the building. And then we see under Section 1.4 of the DPA, a statutory duty is imposed on developers, so those who in the course of a business provide or arrange for the provision of dwellings or arrange for others to take on work in connection with the provision of a dwelling. So looking at what URS submitted, they submitted that the context of the DPA distinguishes between those who owe the DPA duties and those to whom they're owed. So they said that a person can't simultaneously owe and be owed a duty, and that Section 11A does not confer the benefit of Section 1.1 on a developer, so on the person owing a duty under Section 1.4. And URS said that it would be anomalous and illogical for the DPA to be interpreted so as to allow the duty to be owed by and to the same person. Another argument of URS was they said that the DPA was legislation in the field of consumer protection, and that it was not the purpose of the legislation to protect commercial developers such as BDW. They also raised the argument that Section 6.3 of the DPA makes it impossible to contract out of the Act. And since it was hard to see a reason which justified preventing building contractors and construction professionals who work for a commercial developer from freely negotiating their contracts, the correct statutory interpretation would be that developers are excluded from the persons to whom the duty is owed. URS also said that the purpose of the DPA was to address unfairness suffered by purchasers of new dwellings and not to protect developers who do not inhabit dwellings. Well, as I think our listeners probably know by now, the court rejected those submissions, and it looked first at the wording of the section. So Adam, you said when you asked the question whether it was obvious. Well, the Supreme Court, I think, did find the wording of the section obvious. They said that the duties owed under Section 11A to those who order a dwelling, and under Section 11B to those who acquire an interest in the dwelling, which would cover any purchaser of the dwelling. So therefore, they found that Section 11A could be directed at persons other than a purchaser of the dwelling, or those who acquire an interest in the dwelling, but would be the owner of the dwelling at the outset, i.e. its first owner. So to the order of any person includes the first owners who order work in respect of a dwelling, and this embraces developers who order relevant work and are the first owners. So the Supreme Court also held that there is no good reason why a developer cannot both owe and be owed a duty. They held that there was no inconsistency and no logical fallacy in saying that a developer can both owe a duty, for example, to a subsequent purchaser, and be owed that duty. So by those down the contractual chain, so a builder, an architect, an engineer. And the court also said that there may be other situations where those who owe a duty are also owed a duty. So therefore, developers are not uniquely privileged. Now, Lord Leggett, in his separate judgment, also added that the persons to whom the duty imposed by Section 1.1 is owed are not limited to any particular category of purchaser or owner considered to be particularly vulnerable. And he said, if the result is to extend the scope of the statutory protection beyond those who most need it, that can't be regarded as irrational. He also said that it's wrong to assume that the duty imposed by Section 1.1 is aimed only at consumer protection, and that the broader aim is improving the quality of construction of new housing. So to wrap up that section, the court did conclude, therefore, that as the relevant work was carried out by URS to the order of BDW, then URS owed BDW a duty under Section 11A of the DPA.
Thank you. And what about, what did the court decide in relation to the types of losses which would be recoverable for a breach of duty under Section 11A?
And so URS had argued that BDW's alleged losses were not of a type that were recoverable for the breach of that duty, and that the type of damage contemplated was that arising as a result of the ownership of a dwelling, which was unfit for habitation. And the Supreme Court rejected this argument, and it held that there is no question of the costs of repairing defects being of a type that are irrecoverable for breach of that duty. And at paragraph 161 of the judgment, the court held that once it is accepted that the wording of Section 11A contemplates claims by developers against contractors, it follows that the premise of URS's argument cannot be right. The DPA does contemplate losses of the kind incurred by BDW, namely the losses incurred by a developer in remedying defects caused by its contractor's breach of duty.
And why is this particularly interesting?
So this is interesting because the judgment confirms that developers do have a direct cause of action under the DPA against those down the contractual chain. So those who've carried out work to their order for defects which render a dwelling unfit for habitation.
Thank you, Camilla. Now, finally, we're going to move to ground 4, which David is going to discuss. Again, just to briefly recap, ground 4 was whether BDW was entitled to bring a claim against URS under Section 1 of the Contribution Act. So, David, what was the basis of BDW's claim for a contribution?
So, Adam, as you outlined at the start of this webinar, BDW had carried out remedial works to the developments, even though there had been no claims intimated against them by either the occupiers or the building owners. And BDW claims contribution from URS in respect of those costs of remediation. Now, we take a step back and look at the policy of contribution claims. Where a person has suffered damage, let's call them C, or the claimant, they can bring a claim against one of a number of defendants, D1, D2. The claimant can claim against and can recover their loss from one or any number of them. So they could claim everything against the first defendant. Now, that could create unfairness because it's all in the lap of the claimant as to who it decides to claim against, if there was no mechanism to allow that party that the claimant's claiming against to cover contribution from other potential defendants. And the provision that now governs this area of the law is the Civil Liability Contribution Act 1978. And that creates a statutory right to recover such a contribution from other potentially liable defendants, allowing that loss to be redistributed amongst those liable according to the extent of their relative responsibility for the damage in question. So what we see in this case was that BDW sought to claim a contribution from URS on the basis that BDW and URS were both liable to the homeowners in respect of the defects that had been remedied by BDW. Now, URS denied that it was liable to make such a contribution, and the Supreme Court had to look at the underlying basis for a claim for a contribution, particularly where there hadn't been a judgment, there'd been no arbitral award, and there'd been no settlement agreement. BDW had, as we discussed before, done the right thing, carried on works to remedy the developments. Now, BDW submitted the right to recover a contribution arises as soon as the damage is suffered by the claimant, for which both defendants are each liable, even if the claimant had not claimed, let alone recovered, compensation from either defendant in respect of that damage. So, on BDW's case, the right to recover a contribution arose when the damage was suffered by the homeowners, which, on BDW's case, occurred at the time of completion of the developments. The URS adopted a very different position. they argued the right to recover a contribution did not arise unless and until the existence and amount of the defendant's liability to the claimant in respect of the damage had been ascertained by a judgment against the first defendant, an admission of liability, or a settlement between the claimant and the defendant. So, as we've heard here, no settlement agreement, hence URS would argue no right to recover a contribution had arisen, and conveniently for URS, most likely would never arise, since BDW had undertaken remedial works without waiting for any claim to be made against it by any homeowner.
Thank you. So those were the arguments. What did the Supreme Court decide were the ingredients for a claim for a contribution?
So interestingly, in respect of grounds 1, 2, and 3, you have the decision of the Supreme Court being given. Lord Leggatt gave a judgment in respect of ground 4. The other members of the Supreme Court agreed with his reasons, and he rejected both the arguments of URS and BDW, but probably leaned more towards BDW's position. Lord Leggatt concluded that the right for D1 to recover a contribution from D2 arises when two conditions are satisfied. Number one, damage has been suffered by the claimant for which D1 and D2 are each liable, and secondly, D1 has paid or been ordered to pay or agreed to pay compensation in respect of the damage to C. At that point, and not before, D1 is entitled to recover a contribution from D2, and so the 2-year limitation period for contribution claims, in which any claim for contribution must be brought, begins. Lord Leggatt rejected URS's argument. It's necessary that the amount that D1 was liable to pay had to be established in a judgment, admission, or settlement agreement. And certainly he accepted what BDW had done was by way of performance of a settlement. He also, however, rejected BDW's argument that all of the necessary ingredients for a claim for a contribution are set out in Section 1, subsection 1 of the Contribution Act. But that requires, firstly, C suffers damage. Secondly, another person, apart from D1, is liable in respect of that damage. And thirdly, D2 is liable in respect of that damage, which was ultimately the decision of the Court of Appeal. Now, Lord Leggatt said, actually, there are additional elements you need to satisfy before establishing a claim for a contribution. In particular, a contribution is for an amount of money, and the amount recoverable is a proportion of that sum. So it's not possible for a court to make an order for a contribution in favour of D1 against D2 unless and until an amount of money can be identified of which D2 may be ordered to pay a proportion. And as I've indicated before, the sum that D1 paid out should not be restrictively interpreted. It does include a payment in kind, such as where the payment in kind is capable of valuation in monetary terms. And as we know from so many quantum reports we receive across our desks, values of work, such as those undertaken by BDW, can be quantified as a sum of money. Now, Lord Leggatt noted that this conclusion echoes Section 10, subsection 4 of the Limitation Act 1980. Now, where C1 is liable in respect of a settlement and not a judgment or award, which is regulated by Section 10.3 of the Limitation Act, when the 2-year limitation period accrues on, quote, the earliest date on which the amount to be paid by him is agreed between him or his representative and a person, or each of the persons, as the case may be, to whom the payment is to be made. Lord Leggatt interpreted this provision to mean that in any case where D1 makes or agrees to make any payment to C in compensation for the damage, the relevant date is the date when the payment is made, or if earlier, the date on which the amount to be paid is agreed. In this way, time begins to run, as it does under Section 10, subsection 3 of the Limitation Act, as soon as there's an identifiable amount of money in respect of which D2 may be ordered to make contribution.
Thank you. So how did the Supreme Court apply this reasoning to the facts of the case, and what was the outcome?
You have to look towards the end of Lord Eggert's judgment to actually see how it actually affects the impacts on the case. He noted whether or not URS was liable to make a contribution to BDW hinged on the outcome of ground 2, namely the effects of Section 135 of the Building Safety Act 2022. So, for example, if D1 had ceased to be liable as a result of an expiry of a limitation period, question was, did D1 cease to be liable to C when the works were performed? That was quite easy to see. After 28th of June 2022, Section 135 comes into force. BDW was obviously liable for homeowners prior to the works and therefore could recover a contribution. Now, turning back to ground 2, Section 135 is held to have always been in force. So this therefore applies to a claim under Section 1 of the Defective Premises Act 1972 prior to this date. So BDW was liable to the homeowners. It made its payment, or effectively by way of performance. And so BDW's claim against URS for a contribution would therefore succeed on the assumed facts. What I'd also note as a corollary to that as well, as a codicil, is we see a very interesting discussion by the Supreme Court of the Law Reform Married Women and Tortfeasors Act 1935. Those of us who do international work involving common law jurisdictions where the 1978 Act has not effectively been enacted or comparable provision enacted, will find the discussion of the Supreme Court really quite useful about the 1935 Act, and indeed will note remarks about its laconic wording for contribution, and indeed why Parliament chose to amend also to get rid of the 1935 Act when it brought in the 1978 Act.
Thank you very much. Now, we do have some time for questions, and following the panel WhatsApp, I'm going to ask Camilla, who I think has found a question that she would like to respond to. Camilla.
Thank you, Adam. So I can see a question here which says, where the court talked about where a contractor may owe and be owed a duty, they said that that would be where the contractor essentially owned the land. What does that mean, if anything, for claims that seeks to pass down the supply chain? So what I didn't include in my presentation this morning is that at paragraph 141 of the judgment, the Supreme Court held that the words "to the order of the person" are wide enough to cover where that person does not have a proprietary interest in the land and the new dwelling. So I hope that answers at least part of that question. And obviously there are the Contribution Act claims as well that a developer can look to for passing those claims down the supply chain.
Thank you. Right, before we move on to other questions, I just want to, I was just going to touch on Burrell. Burrell is effectively the dog that didn't bark in the Supreme Court's judgment, in the sense that Burrell was the reason, as I said at the beginning, that we had a 7-justice panel at the Supreme Court, and then as it turned out, no decision was actually required. In dealing with Burrell, the Supreme Court made 3 points. First, Burrell was decided on a false premise, namely that cracks in a building constitute physical damage rather than pure economic loss. And that was clear from the overruling of Ans and Merton by Murphy and Brentwood. The second point made by the Supreme Court was that just because the reasoning in Burrell was wrong, that did not mean that the outcome, namely that the cause of action and negligence accrued when the relevant damage occurred rather than when it was discovered, or could reasonably have been discovered, was necessarily wrong. And third, the Supreme Court expressed some sympathy for the argument accepted in other common law jurisdictions that the cause of action accrues when the damage was discovered or could reasonably have been discovered. But in this context, it's important to note that the Supreme Court considered that the position in England and Wales would have to take account of the fact that Parliament had passed the Latent Damage Act 1986, which set a period of 3 years from discoverability and a long stop of 15 years. Now, accepting the date of discoverability as the date of accrual of the cause of action would mean that a claimant would have 6 years not the 3 years given by Parliament. David, where do you think this leaves us with Burrell?
I mean, it leaves us in a very unsatisfactory position. Now, note, Adam, but again, we are hearing the clanking chains of the history of Annes and Merton. Of course, Burrell was decided at a point when Annes and Merton was good law, and you could recover for what is now being decided following Murphy and Brentwood be pure economic loss. And so you see the House of Lords in Burrell making a decision as to when limitation began to run in respect of latent defects. That's then followed by a number of cases, culminating in Murphy and Brentwood, where it's decided that pure economic loss is irrecoverable. And now we get to a position where we see discussion in the Court of Appeal in URS and BDW, where Lord Justice Colson notices the rather unsatisfactory position that the law finds itself in. So where you have a case where there is physical damage to the property in question, that appears pursuant to Burrell to be when you start a limitation running. But where you have a property or a building which suffers from a defect, but that defect doesn't manifest itself in physical damage, and here we have the case of a building that in URS and BDW suffers structural design problems that don't result in physical damage. But more typically, as of course noted in the Court of Appeal, you have a fire safety case where you have fire safety defects, but because there is no initial fire, then they do not manifest themselves in actual physical damage. You will take the approach of adopting a limitation period of running at the latest from the date of practical completion. So where do we find ourselves? And indeed, as the Supreme Court held, the problem is, following Burrell, you see Parliament enacting the Latent Damages Act 1986, which of course is on the assumption that Annes and Merton is good law and Burrell was also to be applied. But then you have Murphy and Brentwood a few years later. So we're still suffering from what Sir Rupert Jackson calls the heroic age of tort, when the scope of what was recoverable in the tort of negligence was still, I'd say, in hindsight, quite uncertain. Now, one of the questions in the discussion is, could this be picked up by statute, or could it be picked up by such a body such as the Law Commission? Well, I hope it would be picked up by the Law Commission, and I'll just very briefly explain why. Are we going to see another Burrell-style decision or URS and BDW-style decision? Probably not a decision involving residential premises, because of the Defective Premises Act now, 1972. And that's going to cover so many cases involving residential premises. So therefore, it's going to be more likely another commercial case like Burrell. But how many parties are going to have the appetite to take it all the way to the apex appellate level? So this is something we'd hope the Law Commission can probably pick up on and try to reconcile what are now a number of issues in respect of limitation. So we do have an unsatisfactory and an uncertain position. In practice, this is going to affect claims moving forward, where we're pleading co-terminous duties under the Defective Premises Act and in the tort of negligence. Are we going to see a resolution to it any time soon? No, because it requires resolution by the Supreme Court or by legislation. That is why we, in some ways, we enjoy academic law so much, so we can argue these points.
Thank you, David, and thank you to everyone else on the panel. And thank you to our audience for attending. Clearly, this decision from the Supreme Court is going to give rise to lots of points of discussion, but clearly it also points in very much the same direction as the Court of Appeal, reinforcing the very strong public policy issues and considerations underlying the Building Safety Act, very much along the lines of polluter pays. And the Court of Appeal and the Supreme Court have shown themselves to be very determined to ensure that those most responsible for significant defects in residential properties end up paying for them, and they're not going to be astute to arguments which allow people that they consider to be responsible for those defects to escape liability. Also, we can see the fact that one of the things they're concerned about is that they understand that a lot of these works are going to be very expensive, and they're trying to make sure that there are as many pockets as possible which are available to fund those works, so that ultimately the residential occupiers are not left in unsafe buildings. But that concludes our discussion today. Thank you very much to everyone for attending. And as I say, I'm sure there'll be far more to be said about this in due course. Thank you very much and enjoy your mornings. Goodbye.